5 seconds to go. Start. It has also to be kept in mind that for the purposes of granting the bail, the legislature has used the words reasonable grounds for believing instead of the evidence, which means the court dealing with the grant of bail can only satisfy it as to whether there is a genuine case against the accused and that the prosecution will be able to produce prima facie evidence in support of the charge. This court in Ram Govind Upadhyay versus Sudarshan Singh 2002-3 SEC 598, speaking through Banerjee, emphasized that a court exercising discretion in matters of bail has to undertake the same judiciously, in highlighting that bail cannot be granted as a matter of course bereft of cogent reasoning. This court observed as follows: grant of bail, though being a discretionary order, but however calls for exercise of such a discretion in a judicious manner and not as a matter of course. Order for bail bereft of any cogent reason cannot be sustained. Needless to record, however, that the grant of bail is dependent upon the contextual facts of the matter being dealt with by the court, and facts, however, do always vary from case to case. While placement of the accused in the society, though, may be considered, but that by itself cannot be a guiding factor in the matter of grant of bail, and the same should and ought always to be coupled with other circumstances warranting the grant of bail. The nature of the offence is one of the basic considerations for the grant of bail. More heinous is the crime, the greater is the chance of rejection of the bail, though, however, dependent on the factual metrics of the matter. This court held that although it is established that a court considering a bail application cannot undertake a detailed examination of evidence and an elaborate discussion on the merits of the case, the court is required to indicate the prima facie reasons justifying the grant of bail. This court observed that where a high court has granted bail mechanically, the said order would suffer from the vice of non application of mind, rendering it illegal. This court held as under with regard to the circumstances under which an order granting bail may be set aside. In doing so, the factors which ought to have guided the court's decision to grant bail have also been detailed as under. It is trite that this court does not normally interfere with an order passed by the High Court granting or rejecting bail to the accused. However, it is equally incumbent upon the High Court to exercise its discretion judiciously, cautiously, and strictly in compliance with the basic principles laid down in a plethora of decisions of this court on the point. It is well settled that, among other circumstances, the factors to be borne in mind while considering an application for bail are whether there is any prima facie or reasonable ground to believe that the accused had committed the offence, nature and gravity of the accusation, severity of the punishment in the event of conviction, danger of the accused absconding or fleeing if released on bail, character, behavior, means, position, and standing of the accused, likelihood of the offence being repeated, reasonable apprehension of the witnesses being influenced, and danger, of course, of justice being thwarted by grant of bail. Another factor which should guide the court's decision in deciding a bail application is the period of custody. However, as noted, the period of custody has to be weighed simultaneously with the totality of the circumstances and the criminal antecedents of the accused, if any. Further, the circumstances which may justify the grant of bail are to be considered in the larger context of the societal concern involved in releasing an accused in juxtaposition to individual liberty of the accused seeking bail. After referring to a catena of judgments of this court in Neeru Yadav versus State of UP and another 2016-15 SCC 422 on the considerations to be placed at balance while deciding to grant bail observed through Deepak Mishra judge as his lordship then was in paragraphs 15 and 18 as under. Stop.